Thank you for your time and your commitment to such a worthy undertaking. I'm Greg Merriweather, welcoming you to this year's Angola Museum Symposium on Race and the Louisiana Criminal Justice System. Our founding fathers, in establishing the new Constitution of the United States government in 1789, committed to the goals of forming a more perfect union and establishing justice. As for equal justice with regard to race, well, that wouldn't really start to appear until some 80 years later with the 14th Amendment. It, though, would be another 100 years before we'd see the enactment of groundbreaking civil rights legislation. The struggle of African Americans to get full rights and be valued as equal to whites has been an enduring struggle, to say the least. A critical component of that struggle has been the often painful relationship between African Americans and the criminal justice system. Of course, equal justice under the law is a fundamental guarantee of the Constitution and American democracy, but yet in the real lived experiences of some African Americans, equal justice has been more of a constitutional promise than an achieved reality. The historic U.S. Supreme Court case in 1896 that ruled blacks did not enjoy citizenship rights equal to whites, of course, originated in Louisiana, the now infamous Plessy versus Ferguson. Until recently, Louisiana was one of only 2 states, with Oregon being the other, that did not require unanimous jury verdicts for criminal convictions. You don't need me to tell you that Louisiana has the highest sustained rate on incarceration in our nation. In fact, Louisiana leads the nation in no parole sentencing. As of last year, about 16% of our state's prison population consists of inmates serving life without parole. That is the highest percentage in the nation. This brief summary of racial dynamics in our state and nation provides a terrific segue into the Angola Museum's efforts today. The title of the symposium is In Pursuit of Equal Justice, Race and Criminal Justice in Louisiana, Reconstruction, Convict Leasing, Jim Crow Governance, and Prison Reform. Museums have an ethical obligation to educate the public on great issues of human affairs in our society. Now, consistent with that obligation, the Angola Museum, in its symposium, seeks to foster a discussion that accurately depicts what we've been through and where we hope to head. There is a lot to learn from Louisiana's painful history regarding race and the state's criminal justice system. The goal, though, is to create a criminal justice system which everyone will be treated equally. So I invite you to not just sit back and enjoy, but sit up and be engaged. This morning can be a start we all need. Thanks again for your time and your attention. And now we turn things over to your moderator.
Hello, everyone. Hello, everyone, and welcome to In Pursuit of Equal Justice, Race and Criminal Justice in Louisiana, Reconstruction, Convict Leasing, Jim Crow Governance, and Prison Reform. We would like to thank you all for joining us today, as well as our panelists, who we are very excited to have here with us today. I would also like to thank everyone behind the scenes that has helped us organize this symposium. It's been great fun, and thank you all so much. Thank you for joining us as panelists discuss the facets of racial history during the Jim Crow era and the effectiveness of recent criminal justice reforms aimed at producing a more just criminal justice system for all Louisiana citizens, particularly African Americans, and suggest ideas about what equal justice could look like in the future. Today's panel summarizes the role of non-unanimous juries and mass incarceration, Today's panel summarizes the role of non-unanimous juries in contributing to mass incarceration in Louisiana and explores efforts to undo the damages of non-unanimous juries and mass incarceration. Funding for 2021 Rebirth grants has been administered by the Louisiana Endowment for the Humanities and provided by the National Endowment for the Humanities as part of the African American Rescue Plan and the NEH Sustaining the Humanities through the American Rescue Plan initiative. The views, findings, and conclusions or recommendations expressed in this symposium do not necessarily represent those of either Louisiana Endowment for the Humanities or the National Endowment for the Humanities. Before we begin, there are a few items I'd like to go over. There is time allotted at the end of presentations for a Q&A and discussion. If you have any questions for our panelists, please use the Q&A feature at the bottom of your screen to submit any questions. If you have any tech issues, general information questions, a question about an upcoming panel, please write that in the chat and one of our support members will respond to you. At this time, I'm going to introduce our moderator for today, Dr. Marianne Fisher-Giorlando, aka Dr. G, is a criminal justice professor emerita from Grambling State University, where she taught the majority of the corrections courses for 26 years. Researcher, scholar, teacher, and volunteer in prison since 1981, Dr. G studies the history of the women in the Louisiana State Penitentiary from 1835 to 1961. Currently, the Education Committee Chair for the Louisiana State Penitentiary Museum Foundation. She is Project Director for the 2022 In Pursuit of Equal Justice Virtual Symposium. Thanks so much. Take it away, Dr. G.
Got it. There, keep my hands off the screen, right? After 3 years of planning and work, we're finally here. Thank you, everyone. And without any further ado, as I've been saying through all our preparation sessions, we want to get to the meat of the subject today, don't we? And it's my pleasure to introduce Dr. Thomas Aiello from Valdosta State University. He's an associate professor of history and African American studies at Valdosta State. He received his PhD from the University of Arkansas in 2007. The bulk of his courses relate to all measures of African American history, from early slavery to Black Power. His research interests are broader, covering 20th century United States cultural and intellectual history, and 20th century African American cultural and intellectual history in a variety of different settings. I have to add something to what Dr. Aiello contributed to us. I believe he's modest. He has 2 PhDs, has published 16 books and another one in press, and is the author of Jim Crow's Last Stand, Non-Unanimous Criminal Jury Verdicts in Louisiana. Take it away, Dr. Aiello.
Thank you very much. I appreciate it. Let me share my screen here with all of you. Can you see that?
Yes.
Okay. So, beginning in 1880, Louisiana allowed criminal defendants to be convicted by 9 of 12 jurors. Beginning in 1973, it allowed them to be convicted by 10. It was a law designed to increase convictions to feed the state's burgeoning convict lease system, and remained in the first half of the segregationist 20th century, even after convict lease had run its course. The principle of non-unanimous jury verdicts in non-capital criminal cases wasn't a unique Louisiana holdover from the Napoleonic Code. It wasn't a legacy handed down from France or Spain or the Holy See, as were so many of Louisiana's other governmental idiosyncrasies. It was a conservative measure, fired in the crucible of Bourbon Restoration following Reconstruction, when white Democrats sought to return their state to some sense of normalcy following federal occupation. The law validating non-unanimous jury verdicts first passed in 1880 and was codified in the Louisiana State Constitution of 1898. It was the era of the Redeemers. It was the era of Jim Crow. And the same leaders reimposing white Southern rule and formulating the convict lease system fundamentally changed a process that had been in place since the American transfer following the Louisiana Purchase, and used it to create more convicts. The State Constitutional Convention of 1898, which formalized non-unanimous criminal jury verdicts, was tinged with racial overtones. It was the session that codified Jim Crow and black voting restrictions. Convention President E.B. Crutchnet opened the proceedings by reminding delegates that this is the convention that has been called together by the people of the state to eliminate from the electorate the mass of corrupt and illiterate voters who have, during the last quarter of a century, degraded a politics. In closing the convention, he praised delegates for perpetuating the supremacy of the Anglo-Saxon race in Louisiana. To help perpetuate that supremacy, legislators needed to combine their attempts at segregation and disfranchisement with a systematic reinstitution of a version of slavery. Louisiana's convict lease system actually began in the antebellum era, when the state first leased prisoner work to private companies back in 1844. That work was originally done inside the prison, turning the penitentiary into a de facto factory. But during Reconstruction, the state began shipping prisoners out to work on construction and repair projects. Most of them went to a contractor named S.L. James, who signed a 21-year contract with the state in 1870 and renewed it in 1890. To facilitate profit and to provide a place for the prisoners to work away from the fears and prying eyes of the public, James leased a large plantation on the Mississippi River. The plantation, known as Angola, served as both an active plantation worked by convict labor and a staging ground for James to lease prisoners to other plantations and business interests. Eventually, Angola would cover approximately 13 square miles, including black sharecroppers on the land to accompany the prison labor. In 1901, the state purchased Angola from James, retained almost all of his employees, no matter how brutal or murderous, and turned the plantation into the facility that brings us all here today. Regardless, the state made a profit. James got cheap labor that he could treat as brutally as he liked. In 1881, the year following the original non-unanimous jury law, 14% of leased convicts died. The next year, more than 20% died. And more than 3/4 of Louisiana's leased convicts after 1870 were black. In light of the racial motivation of such punishments and the overwhelming need of the state for more prisoners to lease to the growing political machine known as the James Gang, the state's change to non-unanimous criminal jury verdicts became almost a fait accompli. The other impetus for Louisiana's non-unanimous jury standard was the service of black members of juries. In Louisiana in particular, black jury service would occur with at least a halting regularity after Reconstruction. Louisiana had an established, economically stable, free black population headquartered in New Orleans from even before its statehood. Thus, it had a population not only qualified for jury service, even under racially restrictive metrics, but one that was willing to fight to assure itself the opportunity to serve. The Comité des Citoyens, the Black Citizens Committee who initiated the case against segregated train cars that would become Plessy versus Ferguson in 1896, was also concerned about restrictions of black service on juries. The same day that the Supreme Court issued its disastrous Plessy ruling, it also issued a ruling in Murray v. Louisiana, which predictably denied that there was any problem with all-white juries. The next year, 1897, the Comité petitioned the federal government, arguing that those in Louisiana are here upon the eve of a constitutional convention, the avowed purpose of which is to disfranchise the colored citizens of the state. Comité leader Louis Martinet traveled to Washington to meet with the Republican administration to call attention to racial discrimination in federal juries. And he was so persuasive that probably the most powerful Republican senator at the time, William Chandler of New Hampshire, had a resolution passed in the Senate calling upon the Attorney General to investigate. As a hedge against such intrusions, members of the 1898 convention decided on a non-unanimous jury standard. They specifically asked the Secretary of State for a racial breakdown of voters by parish, and in New Orleans here by ward, coming to the conclusion that 14.7% of eligible voters were black, and thus 14.7% of potential jurors were black. The best method to override that possible percentage of black jurors, while still allowing them to serve and avoiding federal investigation, was to mandate that only 9 of 12 jurors need to agree to convict. 75% of the total. The Supreme Court would narrowly validate Louisiana's law in Johnson v. Louisiana, 1972, tried in conjunction with a similar Oregon appeal. And the outcome validated the legality of non-unanimous criminal verdicts. But it didn't end the controversy about the approximate justice they provided for criminal defendants. In the century prior to Johnson, appellates had argued that 9-3 verdicts made it much easier to convict. The state countered that they also made it that much easier to acquit. Appellates argued that 9-3 verdicts in non-capital criminal cases overly complicated a system that often tried defendants on multiple counts, including misdemeanors and capital offenses. The state countered that they reduced the number of hung juries, thereby streamlining the system and saving the state money. The Supreme Court was less concerned with such arguments, instead ruling that consistency provided fairness, and fairness was the fundamental bedrock of due process. That fairness, however, has been questionable and continuously questioned. The original 19th century 9-3 verdicts were later modified to requirements for 10-2 decisions, but that did little to make the system more equitable. And as the 20th century became the 21st, it was clear that race still played a role in the formula created by the non-unanimous jury standard. It didn't have the racist odor of poll taxes or separate train cars, and so it remained, with effects that reached far beyond the bounds of race. Understanding segregation laws as racist in the early 20th century, of course, was far more obvious than a similar understanding for non-unanimous criminal verdicts in the 21st. The former was blatantly based on inferiority claims and specifically targeted minorities based solely on their minority status. The latter simply argued for a different standard of conviction, equally applicable to any defendant charged with a non-capital state crime. As criminal appeals throughout the 20th century demonstrated, however, equal applicability was a red herring that distracted from the state's easier ability to put its citizens in prison. It was discriminatory by jurisdiction, as it made prosecution at the state level easier than at the federal level. It was discriminatory by gender, as jury selection and deliberation studies demonstrated. Those studies also demonstrated racial discrimination inherent in Louisiana's framework. But the reality of that discrimination didn't stop at the water's edge of the jury box or the Jim Crow era. In 2005, for example, Louisiana incarcerated 523 white people and 2,452 black people per 100,000, a differential of roughly 4.7 to 1. It was a demonstration of the perpetuation of the systematic racism of a system created to uphold the supremacy of the Anglo-Saxon race in Louisiana. And the development of that history led many in the 21st century to re-engage that fight. And that fight is what we will learn about next. Thank you very much.
Thank you, Tom. We will go next to the Honorable Jason Rogers Williams. Although I want to do a PS, you've got some great images. I've used a lot of them myself, but you've got some better ones. I've got to get them from you later. Huh? The Honorable Jason Rogers Williams was sworn in as District Attorney of Orleans Parish on January 11, 2021. He is a proud Tulane University Law School alumni. After graduating law school, he started his own law practice, Jason Rogers Williams and Associates Law Firm, which focused on criminal defense cases. After winning a series of high-profile criminal cases, the Louisiana Supreme Court appointed Jason to serve as a judge in the New Orleans Criminal District Court. In 2014, he saw an opportunity to make government work for the people of New Orleans and ran for city council. He was a council member for 6 years, 4 of which he served as council president, before being elected district attorney on a promise of sweeping justice reforms. Jason is a proud and devoted father to 3 children, 2-year-old Xavier, 14-year-old Graham, and 20-year-old Zoe. He lives in Uptown New Orleans with his wife, Dr. Liz Marcel Williams, founder and CEO of the Center for Resilience, his 2 young sons, and a very lazy pit bull, Ignatius. My father's middle name was Xavier, so.
Wonderful.
Yeah.
Wonderful. Thank you so much. Thank you so much for that warm introduction, and I will let Xavier know he's got a lot to live up to.
Yeah.
When I took office as a New Orleans DA, I was very, very clear with the people of New Orleans that the New Orleans District Attorney's Office was not was very clearly a Jim Crow office, but would no longer be a Jim Crow office. For far too long, as most of the folks on this call in this meeting realize, New Orleans has been ground zero for the unfairness of the American criminal legal system, predominantly for Black and brown and beige people. This, sometimes called a broken system, as you just heard in a pretty remarkable presentation, was not the result of something being broken. It was a system that was functioning exactly as it was designed and legislated to function. And the system doubled down on the mass producing of convictions and over incarceration in a way that did not produce any public safety benefits. And as a city, I felt that we had a responsibility to fix that. Fix it so that it could be more efficient with dealing with violent crime, but also fix it. Someone said they can't hear me very well. Is that better? But fix the system so that it functioned better, but also fix it so that it was fair. With this in mind, I knew that we needed an intentional, focused effort to address and correct the sins of the past. We immediately created a civil rights division led by the chief, Emily Maw, who was formerly the director of the Innocence Project New Orleans. This division specifically is responsible for one, addressing past harm and injustice caused by previous administrations. Two, increasing the transparency and accountability of criminal justice officials. And three, prosecuting those who exploit vulnerable communities by abusing economic or political power. As part of the Civil Rights Division, with the support of our Appeals Division, we took the office. When we took office, we immediately began working towards delivering justice for those who were convicted using racist, repressive practices of non-unanimous juries. This Jim Crow law that was just described was enacted in 1898 and has caused ripples of injustice since that first constitutional convention. Centuries later, this very racist practice has been responsible for countless people, primarily Black, brown, beige, to be locked up. And that's not right. It's not fair. You fast forward to 2018, after an incredible campaign led by the Yes on 2 coalition. Voters of the state of Louisiana spoke with a very resounding voice, and they voted overwhelmingly to reject this racist system. And we all celebrated this win for the citizens of the state of Louisiana. Everyone recognized that the racism and discrimination of non-unanimous juries, this was community members, this was elected officials, this was conservatives and liberals, this was members of the press as well. And I can't think of another moment when you had a collective like that in one accord. In fact, The Advocate won a Pulitzer Prize for a story on how
the law discriminated against Black and brown people and actually drove mass incarceration. In 2020, the United States Supreme Court affirmed the will of the voters of our state and held that the Sixth Amendment guaranteed unanimous verdict applied to Louisiana. And even Chief Justice, very conservative Chief Justice Kavanaugh, commented that non-unanimous juries were a pillar of a comprehensive and brutal program of racist Jim Crow measures focused squarely against Black people. The court noted that the legacy of racism in Louisiana's law and the interest in securing convictions free of discriminatory taint. And so the work of my office, the work of my Civil Rights Division, I have to say, is standing on the shoulders of an incomparable amalgamation of the Yes on 2 members, including State Director Norris Henderson, Promise of Justice Initiative, Vote, Voices of the Experience, the Southern Poverty Law Center, the Welcoming Project, the Vera Institute, IPNO, Innocence Project New Orleans, Orleans Parish Public Defenders, the Power Coalition, the Jury Project, the Anti-Defamation League, Court Watch NOLA, ACLU, Southern Poverty Law Center. I mean, this was a group lift to convince conservatives and liberals alike that our state was better than this. And being guided by the voice of the people, last year we launched the Undoing Jim Crow Jury Civil Rights Initiative to methodically and efficiently review all applications to the Court of Cases where persons were convicted by non-unanimous juries. And while my office was not at fault and didn't cause this, we certainly were responsible for cleaning and removing the stain on our state's history. We were committed to addressing it head on and making it our responsibility to reckon with the sins of the past. The ultimate purpose of the initiative was to provide people fair, just cases free from any stain of racism. And that doesn't mean that everyone that had a non-unanimous jury verdict, it didn't mean that they were automatically going to get out of jail. Although some of them did get out of jail. And it was about reassessing these cases and re-prosecuting them in an appropriate manner when necessary. And to give you a bit more context about what we faced in New Orleans, in November of 2020, Louisiana's Solicitor General informed the United States Supreme Court that there were 340 non-unanimous convictions in New Orleans. There were roughly 1,600 across Louisiana, and of the 64 parishes in Louisiana, Orleans Parish accounted for over 21% of these cases. So we were a very big driver in the mass producing of these convictions. And if cases were distributed evenly across all parishes, each parish would be responsible for roughly about 25 cases, and that would account for a little over 1%. So we certainly had our work cut out for us. Regardless of that, we started out on this mission. And since the initiative was launched, our office has resolved 64 cases involving non-unanimous juries. 49 of those cases were cases in which a defendant pled guilty to a lesser offense. 2 were cases where the defendant had a sentence that was reduced. Additionally, recognizing the racism and the disproportionate effect of the habitual offender statute, we made a commitment not to use it. 12 of the cases where the habitual offender statute was withdrawn and the defendant was given a new sentence. 3 individuals, including Jermaine Hudson, Callie Smith, were exonerated. Jermaine Hudson This was a situation in which a young man was in jail for 22 years for a crime, not just for a crime he didn't commit, but for a crime that was never committed, that never occurred. The purported victim came forward and shared that he was afraid to tell his father that he had used money on drugs and fabricated this crime. And being a dutiful father, he called the police. They put together a 6-person lineup, and Mr. Jermaine Hudson's photograph happened to be in that lineup. And he identified him, and he went to court, and he was prosecuted for something that never occurred. Callie Smith is a situation where there was DNA evidence, and there was also a recantation of a witness, and excluded evidence that caused Smith to be found guilty by non-unanimous jury. It should have never happened. And so those folks are home and are remarkably insightful about the criminal legal system and the harm that it caused them. Additionally, with the return of jury trials, we are retrying 60 of the reversals based on Ramos versus Louisiana cases, where the office was unable to procure a unanimous jury verdict, and these cases are being retried. In some instances, we will not retry these cases if prosecutors are confident that it is not the right result. But in some cases, we have to try those cases, and we have to put together old cases and find old witnesses. And it is simply the right thing to do. During the very first week of jury trials, Carmen Giago and Samantha Morone, two of my ADAs, tried a case of a defendant who was charged with the manslaughter of his uncle in April of 2014. A jury found him guilty of manslaughter, and this was a unanimous jury verdict, and this was one of the very first cases we tried. The work is, it's about running to some of the most difficult challenges that we face. It is truly about reckoning with the sins of the past. Our goal is to, you hear people sometimes talk about rebuilding trust. And I think rebuilding trust is a wrong word. Our goal is to build trust for the first time in a system that has never earned it. Giving people fair, just trials, and launching this initiative allows us to attempt to repair 120 plus years of injustice. And it's a major step forward, I believe, for the people of New Orleans and for the state of Louisiana in terms of trying to remove a very vile stain. And I'm grateful that you got all of us together to really look at what we've done as a state, as a collective body, to be better than we were in the past. Thank you. Oh, you're on mute. You're on mute. I'll go on mute.
Okay. I thought they were going to do this for me. I wasn't going to have to do it myself because I always neglect to do so. But I want to thank you on behalf of the citizens of Louisiana, on my own behalf and the citizens of Louisiana. I know you have to run, but we're most grateful that you could be here and give us the whole story of the boots on the ground. Huh? Thank you for that.
Thank you.
Our next presenter is Professor Angela Allen Bell, Associate Professor, and B.G. Agnihotri. I messed it up. Endowed Professor, Southern University Law Center. I told the other panelists earlier, I don't have a tongue for different pronunciations. My daughter does, but I don't know where she got it. Professor Bell is a respected local, national, and international legal scholar and expert on civil and human rights, social and restorative justice, and the interplay between race and justice. It was her research that catapulted the recent movement that in November 2018 successfully ended the use of non-unanimous juries in Louisiana. And she is one of the founding members of the advocacy team that led this effort to reform Louisiana's jury system through the adoption of legislation that would require unanimous juries in criminal trials in Louisiana state courts. She has the distinction of having worked on several other historic advocacy campaigns, such as the Angola 3 case, the case of Soledad brother John Cluchette, and the case of Robert Holbrook. The House of Representatives of the Louisiana Legislature of Louisiana has commended her for her achievements as a legal scholar and has recognized and recorded the tremendous pride and honor that she brings to the state of Louisiana. Welcome, Professor Bell.
Good morning, everyone. I've been asked to speak a little bit about the efforts that were undertaken to end the use of these non-unanimous juries in Louisiana. You should know that this particular law was defended by several attorney generals over the years. It was defended by countless prosecutors. It remained on Louisiana's law books for over 138 years. It had become known as just one more unique attribute about Louisiana. And when something is this ingrained, there is no single person, no matter how talented they are, that is able to dismantle it. So this was a case of institutional racism. This required many players and years of incremental efforts to undo such an injustice. My work started on this project in 2015 and still has not ended, and that would be the same for most of the central players in this campaign. And then there were many lawyers before I even got involved that were filing these motions in Louisiana's courts, and they shouldn't be overlooked in this conversation because those challenges have persisted in courts for in Louisiana since the 80s. And so let's talk a little bit about how this was accomplished. And I'll speak in phases because essentially that's how this worked. So phase one was the community education and advocacy phase. And there was really no consensus amongst the group as to whether the law would be changed through litigation or if the law would be changed through legislation. It was my strong view that this was going to have to be fixed through legislation, and I was one of the people who could not be convinced that there would ever be a judicial remedy. And then there were others in the group who felt differently. And so we decided to pursue all routes simultaneously. And so on the legislative side of this, there was a team, and on the litigation side, there was another team. And the leaders I would suggest that you would consider when we talk about litigating this issue is, of course, public defenders around the state of Louisiana who made that commitment to raise these challenges, even though they were routinely denied. And then there were people like Richard Bork and Ben Cohen. Richard Bork is at the Louisiana Capital Assistance Center. Ben Cohen was at the Promise of Justice Initiative at this moment, with the partnership of Calvin Duncan, who were the litigators behind this. And then on the legislative side, there were people like Marjorie Esmond, who I affectionately describe as the mother of this movement. She was the ACLU director at the time, and it is because of Marjorie that this initial core group formed. And that group unveiled its strategy in 2016 when we held our first community talk. And on the panel that night, after Marjorie did the opening, was myself, Calvin Duncan, and Will Snowden, who had founded the Juror Project and had devoted his professional life to this issue of jury justice. In the audience that night was Ed Torpley, Emily Moore, who at the time was directing the Innocence Project, Channel 9 News, and The Advocate. And we would leave that room that night with this team as this central group on the legislative effort. And I add the advocate into that because their involvement started that night. And many people saw the series in 2018, Tilting the Scales, but that series was started in that room that night when the advocate heard the need for something more than just anecdotal evidence as to why this system was bad, not just for Black defendants, but for all of the people of Louisiana. And so I worked in partnership with the advocate that night and over a course of weeks to start discussing how we might do that data collection. And that laid the groundwork for the series that we all now understand played such an influential role in changing this law. So what kinds of things did we do? I ran an email list to make sure that everybody saw all the research, legal developments, studied what was happening in Oregon because they were the only other state doing this, to be sure that everybody understood that we had an alliance with Oregon and that we could join hands in this fight. All of us were strong, talented people individually, so we all wrote op-eds and articles so that we could tell the public and then equip them with something to read. In addition to our writing, we all relied heavily on Tom's book, and we shared that with the public as a resource. We talked until we couldn't find anyone else to listen to. We spoke to civic groups and church organizations and legislators and lawyers and judges and community members, and then promptly went to the state bar and secured a resolution to get the bar involved. I worked with the American Bar Association and secured a resolution to get the American Bar Association involved. And then we reached this moment in 2018, but there's an unrecorded part of this story that needs to be told. And that is when I received the email from Representative Edmund Jordan, who said, I have watched this 2-year crusade, and I am now willing to put forth some legislation. And so it is important that Representative Jordan's commitment be recognized because he put forth the very first constitutional amendment. And then in March of that same year, J.P. Morrell introduced an amendment in his own legislative body. We know that the legislature also agreed that this should be put forth to the voters for a vote. And we know that is how phase 2 starts, with a voting campaign. I am a state employee, so my role changes at this point. Ben Cohen, who is at the Promise of Justice Initiative, now takes over the helms for this voting campaign. They hold a meeting and decide in that room that Norris Henderson is going to lead. And it is at that moment the Unanimous Jury Coalition is born. I want to point out that at that time in that room were all of the players from stage 1, was all of the stakeholders in the community and all of the organizations who cared so much about this issue. Their commitment never died. And I also want to note that the ACLU was one of the strongest organizations pushing for this. Marjorie Esmond retired. And so by this point in 2018, Alana Odoms is taking over the ACLU. At this point, Emily Moore is shifting her directorship over to G. Parks. And these are two really very important, powerful groups in this movement. And with this change in leadership, there is never any change in commitment on the part of those two groups. And so the fight continues with those two groups, and many others join into this coalition. And so what started off as a commitment to change a law soon became a movement. And so now we get this vote. It is only prospective. It is not retroactive. So we have a phase 3 that is being led by Jamelia Jefferson to address the issue of a remedy for those people who did not get the benefit of this law change. And so you may be wondering, why would all of these people take years of their lives to try to dismantle this law? And so to understand that motivation, you really need to start to reimagine the significance of what a jury is and what a jury does. And so I'll speak to that. A jury is so much more than just a random group of people who show up to make a decision. In a criminal sense, they perform an important public safety function because they protect us from people who shouldn't be amongst the public. So the accused, they are about making sure that the strong arm of the government does not take anybody's liberty in this country without justification. But we often overlook that the jury is also significant from the standpoint of the citizen. And I want you to consider this as you think about a jury, because this is the way the average citizen involves themselves in the democracy. It is usually through voting and jury service. And so when we allow a citizen into the jury box, we are saying to that citizen, you are included. And when we say to a citizen, you cannot participate, we are saying that you are excluded. And so we have people who are either in the center of a democracy or we have people who are on the margins. And that is something that should not be overlooked. And so when we get this jury, we're asking them to make reliable decisions. We're asking them to make accurate decisions. And at this point, there's a lot of science that tells us how to get that right. So we know that when we put people in that jury box who are all of the same race or all of the same mindset and all of the same viewpoints, they're often not going to deliberate very long. We know that the deliberations are going to be rushed, and as a result, they're going to make mistakes. But we know something different happens according to the research when we assemble a diverse group of people. And when I speak in terms of diversity in this context, I am not speaking of just race. I am speaking of age diversity and thought diversity and experience diversity and religious and perspectives and socioeconomic. So the goal here is to get a people with a range of perspectives. That is the objective here according to the science. And when you accomplish that, the deliberation time slows because there is now questions and there's now exchanges and there's now challenges and there's now corrections. And we know that these diverse juries make fewer mistakes because they don't move as fast. They consider the evidence more thoroughly. They are going to never presume guilt, but always try to decide whether guilt is justified, and they're more likely to correct inaccuracies. And so in my final moments, you may be wondering if this law changed and this history was made, why is Professor Bell still here talking about juries? There's a reason, because the fight was not just for 12. The fight was about composition. What 12 do we get in the jury box? Otherwise, we don't have anything accomplished with this change of law. And so what we're dealing with now that we have this change of law is currently still an underrepresentation of people of color in Louisiana's jury boxes. There's three reasons why. One, we have courts who like the idea of using voter registration records to select who gets on the jury. And we know that that means you're going to have people of color underrepresented. Two, we have courts who like to send out a jury summons and do nothing if it comes back undeliverable, which means there's no effort on the part of the court to get that diverse jury out. And third, we know that there is a sense of apathy amongst potential jurors who sometimes are just not interested or willing to serve, or it presents a hardship for some people. And so what I would ask you to consider as we depart is that there is just no other arena of public life that I am aware of that is tolerant of this level of discrimination. And so I ask you to consider that the fight was certainly to get 12, a unanimous jury of 12, but it is the right 12. It is the composition of the 12 that we must now focus on at this hour. And we are not able to declare a victory until we achieve jury diversity in the state of Louisiana. Thank you.
Right. Thank you, Professor Bell. That was eloquent. Now we see how many people have to come together to make this happen. And it appears that you got the diversity of the people to make it happen. hopefully we can continue to do so. Thank you so much. Our next presenter is Edward Ted James. Edward Ted James has just been asked to hold a different position at a higher level than a state level right now, but he has agreed to join us for this presentation today. Let me tell you a little bit about him. Edward Ted James' passion for leadership is driven by a deeply held desire to impact the lives of others while transforming the community he simply calls his village. He is a cum laude graduate of the Southern University Law Center, having served as president of the Student Bar Association. Prior to his election in 2011, Ted James held several positions in Louisiana government, from serving on the Louisiana Commission on Housing and Community Development to staff attorney with the Louisiana House of Representatives. He was appointed to serve as special counsel to the Secretary of the Louisiana Department of Revenue and later the Louisiana Advisory Commission on Intergovernmental Relations. In November of 2011, Ted James was elected to serve as Louisiana State Representative for District 101. Through his hard work and dedication, Mr. James immediately emerged as a leader in the Louisiana legislature. He served as the chairman of the Administration of Criminal Justice Committee and chairman of the Legislative Black Caucus. That's our loss, even though it's the SBA's gain, huh? In January 2022, Mr. James was appointed by President Joe Biden as the federal small business administrator, overseeing Region 6, which includes Louisiana, Arkansas, New Mexico, Texas, and Oklahoma. And thank you so much for being here this morning. We know that there have been things you need to attend to because of another crisis hitting Louisiana. I don't know how many of my students I will hear from who were not able to send in assignments, but we thank you for your service. And please, we're waiting to hear your comments.
Well, thank you so much for that introduction. So excited to be on this panel with folks that did the lion's share of the work, and Professor Bell, who initially when this conversation started in the legislature, me knowing the body in which I served in, I would be lying if I would sit here today and tell you that I thought that bill was going to pass. I can remember conversations with Edmund Jordan, and I'm so glad that Professor Bell mentioned the work of Edmund Jordan, because a lot of times his work in this space has been overshadowed because of all of the theatrics and most of the debates took place regarding the bill that former Senator, now Councilman J.P. Morrell carried, but Edmund was extremely dedicated to this particular issue and eradicating this piece of racism that existed in the books of Louisiana and our Constitution for far too long. I was asked to talk about just how the retroactive application of Ramos could affect the Louisiana criminal justice system. And I think that D.A. Williams really talked through it, because he talked about what every DA across the state should be doing right now. I will tell you all from the debate on this bill in criminal justice, we had what I felt like was a very instrumental moment, in that a former district attorney sat and he sat in the front of the criminal justice committee and basically said, I know this is rooted in racism. I understand why we're here today, but it is what it is. So let's just keep it that way. And then there was another district attorney there, and he always, every time he came to the legislature, he would say, I am the only district attorney that ever prosecuted a white man on death row. And he would always brag about that. And, and me, I asked him several questions. I had an exchange with the district attorney, and I will tell you that the district attorney, one of the things that strikes me to this day is the fact that as I talked to him, he didn't even give me the respect to look me in my face. And that was just the arrogance of, I think, a lot of folks in the past and district attorneys that had the benefit of this law, and knowing that it was rooted in racism, frankly, didn't care. And I will tell you that at that moment, I realized that I was really playing a very, very small part in history. And it's one of the probably the final moments that I had in the legislature. And I will tell you that in answering this question, a lot of what we heard as reasons not to pass this bill were some negative implications on the system that other folks tried to deduce from what would happen when this passed. And they talked about, flooding the courts, right? We would have so many people, so many defendants running, filing motions, and this would flood our courts. This would delay justice. This would do all types of things to upset the system and make people uncomfortable for the erroneous decision that Louisiana made 100+ years ago. They talked about, what about the victims? And, now we have to have victims to relitigate these things. And what about witnesses who are no longer here and we can no longer locate? What about ADAs and district attorneys who are no longer here and we don't have that historic information about these cases? And for me, my answer then is the same as now. So what, right? It's never an excuse against doing the right thing. And so those things that we heard then, of course, are issues today. I think that one of the things that the district attorney talked about, and I wish that other DAs had been willing to do with the number of cases, we could have probably gotten through the lion's share of those cases already, because not each and every one of those cases was going to lead to another full-blown trial, right? They could have been cases that, folks would have been freed and they would remain free based on the time that they spent in jail, right? There are some cases that they could have come and entered into other pleas, just a litany of issues that could have happened before a full-blown trial with bringing in a jury and complicating or prolonging justice, as folks said, to eradicate that wrong. And I will tell you that for me, it was not about the money that the courts would have to spend in addressing this issue had Ramos been applied retroactively, because when I look at the number of defendants on the other side, those folks that were prosecuted under this racist law, most of those folks look like me. And even in conversations post, the voters of our state overwhelmingly saying that we want to correct this wrong, many DAs wouldn't even give us the true numbers about what the population looked like, what those defendants looked like. A lot of them, really were almost upset at the notion that we asked the question, right? So I think that the effect would have, if Ramos had been applied retroactively, the effect of the criminal justice system or the criminal legal system is that it would have restored some faith in it, right? It would have given people the opportunity to say, you know what, we could point to so many ills and so many wrongs, but for once we did something right, right? And I think that would restore a lot of faith. I think that just the moral implications of those families, the moral implications of some of those individuals, especially knowing that we sit here in Louisiana in a state that leads the nation in wrongful convictions. So not only have we still have so many individuals out there that were convicted on a non-unanimous jury, but some of them were probably convicted on a lot of faulty evidence. And some of the same practices that many of those DAs didn't want us to uncover. And I'm not, I don't want to cast just a spell on all of the DAs, because we've had several that have, at least attempted to do some things, not to the same scale as DA Williams, but some members of that community have, worked with advocacy groups. In my law practice, I know that one of my law partners specializes in these cases, and he's worked in several jurisdictions, and some DAs have quietly, they haven't come to the legislature to advocate for it, but they've quietly helped, right? So, and that is a small victory. And I will tell you all, just to thank you for having this type of conversation. I am in St. Bernard Parish now, awaiting some preliminary numbers to see what the SBA can do in response to the tornado that we had in this area on earlier this week. So I will hang on for a little bit if there are some questions. But thank you all for all of the information shared. It's and I would say thank you to Professor Bell. In the legislative process, things take time, and we talk about the years that was spent to do this. I know it wasn't easy, but those of us on the legislative side that a lot of us we got all of the high fives and the praise, but we did the easy work, right? You guys really did the lion's share work, and not only bringing the issue to us, preparing us for the legislative debate, but also making sure that the campaign went the way it should have gone, and the people of Louisiana helped to really put what I thought was the final piece, but now we still have one more leg to go. So thank you all for the work that you've done on this issue.
Thank you, Mr. James. I can't thank you enough. I do have to preface my thanks with, we did say that none of these statements or opinions were those of NEH or LEH, and they're not of the Angola Museum either. This is my personal, some of the remarks I've made are my personal opinions here today too. But we welcome you. We thank you so much for taking time out today from your other duties to participate. We have some questions. I'm not sure. I think one of the questions we received ahead of time was what is being done to address these historical issues. And I think DA Williams addressed that, at least how it's being done in Orleans Parish for the non-unanimous juries. And I'm going to save this other one because it's a big one. It's kind of like, I think I can
add to it. I can answer that question.
Okay.
Last year there was a bill filed by Representative Randall Gaines, and the bill, of course, was not successful. And I think that there was almost a commission or something that was formed to study the issue. Quite frankly, and I haven't studied it. If there's not an instrument in the legislature, there should be one that's filed every single session until we get it right. And that, of course, and I'm glad you said that. I have to say again that these are all Ted James opinions. They don't represent any opinion of the Biden-Harris administration or the SBA. So it's just me.
Right.
I want to add one thing to that question that was asked as to what is being done, because this is necessary that we understand the extent to which we victimize people in Louisiana with this particular law. There are people who were so afraid of juries in Louisiana that this law incentivized people to enter into plea agreements. And so there are people who plead to offenses to avoid the wrath of this law, who will never see a remedy because of the fact that they were never convicted by a non-unanimous jury. They incentivize these pleas. So let's not overlook these people as we talk about solutions. In addition, I was in Angola speaking to the men when this law was getting ready to head to the legislature about what was coming. And during that exchange, I said to those people in custody, you need to get your polling records in order. Because if this happens, you're going to have to be able to establish if you were in fact convicted by a non-unanimous jury. And we discovered something tragic. The men who were coming out of some parishes could not obtain polling records. And so they sent me a letter and said, there is some conspiracy, they're withholding these records. And so when I called a few of the clerk's offices, I found out that their policy in some parishes was to shred them. So there is physically no record in some parishes of people being convicted by these non-unanimous juries, although they were, because the polling records were shredded. And so those people now will have no remedy under the law. And so I want to make sure as we have this conversation that we don't overlook the full extent of the injustice and the incalculable harm that has been done to people in Louisiana as a result of this law.
Wonderful comments. You're educating me. I have been so immersed in organizing this program that I've not been able to do as much research as I need to do. And you all know I have some other things, but we have to thank Mr. James. He did have to run. I'm not going to do the head of the pin question because I think we'd all be here all day. And that's the one, I'll throw it out there, but I'd like to respond to the people that are here today because I know where this other one came from. It came from another participant that they can address it later. The first question that came up this morning from former warden Kelly Ward, what are other DAs doing? And I think maybe we've covered that some of them are starting to speak to the issue of non-unanimous juries. It may be slow to move. I know of a couple that are speaking. I don't know if you know, Professor Bell, do you know of any others right now that are addressing the issue? I think Judge Stewart is looking at a couple in Caddo Parish. I may be wrong. I know there's somebody on here today that would know better than I do.
I think that's the extent that I have heard as well, that there's some commitment in Caddo to reevaluate some of these cases. And from some of the opposition that was filed in Ramos and Maxey, and there is still a sentiment amongst the district attorneys that this is defensible. So that has not been put to rest in the state yet. We don't have a consent on the part of DAs to face these convictions and undo them.
Right. I'll get on to, I'm going to skip the next one asking specifically about things going on at the museum. We have some of these subjects. We don't have all of them, but part of this symposium is part of a bigger project where we in fact do plan to make the museum more transparent than it's ever been before. But that's a long haul, and we're suffering like small museums. I'm going to put that pitch out there. We're down to 2 employees. But let me get to the next question. From my old buddy in graduate school, Dr. Norman Rose, do panel members agree with historian Edward Ayer's contention that Southern prisons were originally built to incarcerate small white farmers and indentured servants as opposed to slaves? And I might be able to answer that. I mean, Tom, do you want to try, Dr. Aiello? But I think I could answer this too, but I'll give you the shot, huh?
Oh yeah, sure. Right, so that is technically true. Slaves were considered personal property, and so it wasn't the business of the state to put them in jail. That would be essentially taking away someone's property, and it became the bedrock of the argument for convict lease, of course, because if you only build intentionally small facilities for only a few small people, for a small group of people, then you can say, well, we don't have the infrastructure now that slavery is over to accommodate this mass of corrupt and, criminal people. So therefore, we have no other choice but to lease them out. And so not only were those original prisons only really built for small white farmers, but they also became the excuse used by white redeemers after the Civil War, specifically for the particular way that they decided to start incarcerating the newly freed population, one that has never really gone away.
Right. And Louisiana had that problem. I'll answer very quickly because Louisiana did incarcerate slaves before the Civil War. But there was always the debate in the legislature that, in fact, those walled penitentiaries were built for white men, and it wasn't a sufficient enough punishment for black men. And it was humiliating for white men to be there with the enslaved. The debates were just incomprehensible to me reading them. But let me get to the next question online here. Professor Bell, were you able to add those points that you wanted to answer, that you wanted to address? You did. Okay. I lost track of the other communication. Dr. Kat from LSU, her question is, how do you stay hopeful? It seems as if at every turn there is more harm, more roadblocks, more violence perpetrated by the criminal legal system. How do we stay hopeful and motivated to make change when white supremacy rears its ugly head at literally every turn?
Is that directed to anyone in particular? Okay, I'll be happy to answer that because that is the calling of this chapter of my life. I have now been a lawyer in the state for well over 25 years, and I am convinced that our current system is victimizing people. I think that we need to reimagine the way we are looking at justice systems in this country and think more about crime being an offense against people as opposed to crime being an offense against the state. And so what keeps me hopeful now is that I am a student of transitional justice. And that is very underused in the United States, but it is a solution that I think we should be embracing at this hour. And essentially what it does is where there is a system of human rights abuses, perhaps there's been a dictator and he's crushed people's civil rights and human rights, and we want to transition to a democracy or to something that is not as destructive. We have pillars that we need to consider. And so whenever you want to rebuild something that is this infected with racism, I think we should be thinking in terms of these pillars. So we're looking at truth telling first and foremost, which is what we're doing today, by the way. Correcting the narrative so that people better understand what we are doing and how it is harmful and not good. In addition, we think about prosecuting when that is necessary and useful, but we think also about reparations. And I am not speaking cash dollars. I am thinking of ways to repair harm. So also, lastly, transitional justice embraces the notion that we comb through all legal and all policies to see where we can make reforms that are not based in supremacy. And so we are transitioning to a law system, a legal system, a policy system that is not based on racial hierarchies or notions of supremacy, but based on notions of equality. This particular law was a transitional justice moment because it is that reform of law to get out of these racial hierarchies into something now that is built on equality principles. So I think if we look at the pillars of transitional justice and the way they allow us to be creative in restructuring the system, I think that this is going to lead us into something that is not going to be destructive to people, and that is going to build something that is going to provide a safe public safety outlet. By the way, DA Jason Williams' office is implementing some transitional justice strategies. So we're going to see that work in that one office, and hopefully it will become a template for other DA offices around the country. But this transitional justice is our hope at this moment for abandoning this system that is built on racial hierarchies and transitioning us into a system that is built on equality principles.
Yeah, I also hear parts of what we called restorative justice decades ago, the reparation and the fixing the harm that's done to all the participants in whatever offense it may be and wherever the offense comes from. You're absolutely right. Restorative justice didn't go far enough. It lasted for a while, but I see where your ideas are encompassing even more. We have another question up here. Thoughts on inmate labor. And I don't know that I can answer this at all. Louisiana has a long history of using inmate labor. Is it reformative or rehabilitative? Is it about the money? When I teach my corrections course, I always say, follow the money. It's always about the money, But I'm not, it is and it isn't. It's always more complex, the answers aren't they, huh? So what about the loophole in the 13th Amendment? We're hearing a lot about that recently. What are your thoughts on that, huh?
Well, I think when you are truthful, because we're truth-telling today, we are talking about a former plantation that was owned by a former Confederate general, employing Black men, majority, to do agricultural work. There is no way to accept that as being anything other than rooted in slavery. So I don't oppose the idea of rehabilitation or introducing job skills to people when they're in custody. I think that is very necessary to ensure that they're able to reintegrate into society. The question is what job? So are we producing agricultural workers so that they can become slaves when they exit the penitentiary? Because then that's logical. But are we introducing them to jobs that might keep them employed on the other side of the penitentiary? Then that is logical to me. What I see taking place inside of the walls of many of Louisiana's prisons is not the type of training that will allow a person to enter society and be constructive, tax-paying citizen. Those skills are not being developed enough behind bars in Louisiana. And again, I don't oppose labor. The question is what kind of labor? So I am one who endorses the idea of labor models that will allow a person to become a tax-paying citizen upon release, not growing cotton and planting the seeds that were used during slavery. That would not be the labor model that I would endorse. And on the question of the exceptions clause, I'll speak very briefly because I know there are other speakers. Yes, that is a problem. And yes, that clause should be removed. But I want to caution you that if you take that clause out of Louisiana's Constitution or out of the federal Constitution and you do nothing systemically about any of the other issues we're talking about, we have nothing different. So I don't suggest we leave it. I just would urge you to consider once you take it out, you still have a systemic problem in terms of the fact that we have a justice system that is not properly funded. We have public defenders who are not properly funded. So we cannot take the clause out and expect something different to happen when we still have to fund our justice system off the backs of the public. So we have to figure out a way to charge people if we need the money. We have to charge the bail if we have to have money. So we have to build a system that is not dependent on people. By the way, Justice Weimer just gave his State of the Judiciary address to the legislature. He said this. Justice Johnson, when she was Chief Justice, had been saying that for the last several years. It's been said too much. Where is the action now to change the funding structure in the state of Louisiana? Because that is a large part of why it is that we have this need to keep feeding this machine because so many people are dependent on the funds that it generates.
Okay, well said, Dr. Bell. And I'm gonna, let's see. What about the importance of advocating for new trials opposed to hoping for parole for those still in prison under it says unanimous juries. I think they meant non-unanimous juries. They might have. We'll wait and see if this person, because I think that commission talked about how they're going to address. Yeah, they did mean non-unanimous. And I watched that first commission hearing where the different actors in the system were debating how they're going to address the non-unanimous juries, what route they should take. And so the speaker here is saying, or the question here is, can we discuss the importance of advocating for new trials opposed to hoping for parole for those still in prison under non-unanimous juries?
It's my understanding, and I think Jamelia Jefferson will be speaking more about this, but that is an option that is being entertained and considered as a result of that commission that's been formed, and it's one that I would support.
Yeah, I saw that option, but I also saw opposition to it in that session also. But you're right, and so we can ask our viewers today to make sure they check in and register for the last symposium because, or the last webinar, because in fact, the future and how these things are going to be addressed, or these issues that we've discussed today, they will discuss where we can go next. How are we going to achieve equal justice in this society, huh? Let's see, did I get everything? And I'm going to paraphrase this a bit, but I'm starting to see that some folks have had trouble doing research, and I know in the history, I'm not a lawyer, so I always preface my statements with not being a lawyer, and I don't really understand how the law works, and my friends keep telling me even about the bills that are coming up now, and I have to take copious notes to make myself understand. But I think we've had trouble doing research in the state of Louisiana. I think it's getting better. I know some of the research, I know the Department of Corrections may be improving with allowing people to do research. And all state agencies have these procedures. I know I had to go through them. Actually, though, I think I had more difficulty getting approval from my university than I did from the Department of Corrections, but that was in Ohio, and that was years ago, huh? I see that, you know, I don't know what the process is. I know what the process is here now. I know there are more people that seem to be getting access. But what we're talking about today with the jury system, it's the DAs. And there's always been a problem. I guess you could do the research and you would find out that a plea bargain had gone on if you track the research from when somebody was arrested and the initial charge, and then the final charge when they go to court. So you know then that the DA was the one that negotiated that plea bargain, don't we, huh? And so then we can see what's going on. Before there was the thought that researchers could never get into the DA's office to find out what the discussions really were. There were other agencies, their documents and their proceedings were public. Before we had determinate sentencing, you could always get a judge. You always knew who the hanging judge was, didn't you? All you had to do was sit in the courtroom and take a recording of what they were, write down the data, keep track of their sentencing, right? So I guess we're getting the message. We have 5 minutes, and I did want to give thanks to everybody, huh?
Yeah, I just wanted to come on and see if our panelists had any last few comments before we finish up, and then whenever you guys are complete. Again, thank you everyone for attending and joining us today. Do not forget, tomorrow we will be back here again at 10:30 for our next panel. Thank you.
And I would add to the research question that you should consult the clerk's office to see if there's any minutes or transcripts or records available from those proceedings, if it's a particular case that you are looking into. And secondarily, research, I want to mention that oftentimes in Louisiana, people go looking for cases, but we are not a common law jurisdiction. And I want to remind you, as you think about doing this work of dismantling injustice, that we are a civil law jurisdiction, the only one, by the way, of all the states, which means that we should be having law represent the will of the people. Judges should not make law in a civil law jurisdiction. The will of the people should represent what the people feel is law. So don't overlook the legislative process as you start thinking about making changes in a state like Louisiana, because that is the design of this state. So if you want a remedy, if you want to reimagine a new justice system, you should be interfacing with the legislature to get those types of laws on the books. And that's, by the way, the inspiration that led this movement.
Dr. Aiello, you have something to say? You've been relatively quiet recently.
Yeah, I don't know. As an historian, I'm way more comfortable with dead people than people who are alive. But I think I would say that the kind of things that we're discussing today are going to, sorry, I have dogs going crazy, are going to be the next draft of history. And the idea that we have all of you here today concerned enough about this to want to learn and want to do research about this and want to find out more is only going to ensure that the next batch of historical writing about this subject isn't going to be dependent upon shredded documents and various forms of cover-up. If our being here today is part of the light that we shine on a system. And the fact that we can come here and meet here through the Angola Museum, I think, is significant as well. I have several friends who write history of prisons books who have had their books banned by prisons like Angola simply because they don't want prisoners reading about Attica, and they don't want prisoners reading about these various movements within these systems. And the fact that we can be here today and discuss it, and that we can do it through the Angola Museum, I think is significant in and of itself.
Thank you so much. Thank you so much for being here today. And I want to thank one person who really has been my co-director through all of this, but likes to stay in the background, Dr. Yui Perry. We could not have gotten through this without him. I want to pull up a comment over here. I talk a lot, but I never feel like my words are adequate enough. And I'd like to read this thanks from one of our viewers today. I think it says it better than I could. Thank each of your panelists for your frankness, transparency, and tenacity to see change in our justice system. I can't think of it, although I see two more messages. Thanks for the webinar. And I have to thank you all, and I have to thank our viewers here. We reached into the 70s before people started leaving. I can't tell you all how grateful I am for your participation, for your tenacity and perseverance, and the extra work it took to put this on. Zoom looks real easy to all of us, but it took a lot of practice, to be honest with you. And I was even practicing yesterday and realized I didn't want to shuffle papers on camera. It made a lot of noise. Thank you so much. This has been worth it for these 3 years. Thank you.